Board of Appeals in the District, State of Florida, is now in session. Honorable David A. Monaco, Judge, presiding. All persons citing business for this court draw near, give attention, and you shall observe. Across the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning and welcome to a session of the 5th District Court of Appeals. The panel today consists of Judge Evander on my right, your left, Judge Cohen on my left, your right. We have 3 civil cases scheduled for argument, and we're going to have a change of panels after that for a criminal case. Civil cases get 20 minutes per side. If the appellant wishes to reserve any time for rebuttal, let me know, and I'll try and give you a warning on that. There's a clock on the podium as well. If you have any communication device that's going to make an obnoxious sound, I ask that you turn it off now. And with that, let's begin with the first case, Singer Asset Finance Company versus Jack Green.
Good morning. May it please the court, my name is Chris Carlisle. I'm here on behalf of the appellant Singer Asset Finance Company. I'd like to reserve 5 minutes, if I could, for rebuttal.
Got it.
Thank you very much. Your Honors, we raised numerous issues in the briefs in this case, but I'm going to spend the majority of my time this morning focusing on what perhaps we can all agree is the key issue in this case, and that is the determination by the trial court that Green and not Singer was the prevailing party in this action. This case has a long and complicated procedural and factual history, but the issue that
we're all getting kind of sick of it, actually. This is, I think, we're getting kind of sick of it. This is the 5th or 6th time this case has been up here. It's
been up here a couple times, yes, Your Honor. Despite that complicated factual history, the issue on the prevailing party when before this court today is not terribly complicated. You have what has been described and what was argued to the trial court at the hearing on the motion for entitlement of fees actually in that, but also at the trial many times by opposing counsel by saying this is a breach of note case, and that's what this case was. This is a case where Singer sued to recover.
The facts of the case. Isn't the trial court really in the best position to know what the significant issues were in the case and to make a determination as to who the prevailing party was?
Your Honor, again, there's no dispute that the court has some discretion or has discretion to determine who the prevailing party is.
Well, but isn't the standard abuse of discretion?
Absolutely.
And so how did the trial court abuse its discretion in this case?
Your Honor, this court has not hesitated on many occasions to find an abuse of discretion when the trial court makes a clear error, as it did in this case concerning the prevailing party. We cited a number of cases, particularly in the construction lien context, in homeowners association context.
Construction lien, you have a specific statute that addresses, the issue of prevailing party in a construction lien case. Here you've got Musselwhite, which sets out the standard. You've got a number of cases that set out a standard for determining who the prevailing party is. But my question is really, how did the trial court err in this case?
Your Honor, while there is a statute, again, backing up to your construction lien comment, there is a statute that talks about the awarding of prevailing party fees in a construction context. However, the cases that interpret that statute, including the 3 that I cited from this court in recent years, all rely on Moritz versus Hoyt, which is the standard that we're talking about. What is the significant issue? And this court, in other cases, has noted that the significant issue is one that is generally focused on the result obtained. In this case, none of the issues in this case would exist if not for suing on the note. If the note was paid, none of the collateral issues would even exist in this case. And similarly, when one is foreclosing on a construction lien, that is the essence, that is the nature of the prevailing, the significant issue in the case. Even in situations...
The note was paid. Usury was the defense in the case.
Usury was a defense.
It was also... because the note wasn't paid, because the party raised affirmative defenses, that's it? That's the end of the story?
No, Your Honor. More than that, I think it's important for the court to focus on. It was not just an affirmative defense. There was an affirmative claim for relief and a counterclaim seeking damages from the other side. Counsel, in his opening statement at trial, said, what is left for this court to determine is, 1, Singer's claim for money damages for breach of the note, and 2, Mr. Green's claim for money damages against Singer as a result of the usury violation. What happened with those two issues that were framed for the trial court in this case? Green prevailed, got every penny that he sought of principal. The claim for money damages, Singer prevailed and got every penny that they sought as far as the principal goes. Green's claim for money damages got a 0. If you're talking about the two issues in this case that were framed at trial, one party clearly prevailed, one party did not prevail.
Well, but the trial judge, if I remember, Mr. Carlisle, specifically concluded that the issue of the debt on the note was never, or the principal on the note was never truly conflicted.
That's
the issue that the trial judge saw as the critical one was the one on interest, on the usury matter, wasn't it?
Well, again, Your Honor, I think that is an interesting situation where you go from the final judgment.
He said that the appellee almost essentially conceded the note issue.
At trial, that in fact was the case. But I think, again, you have to look at the history of this case. And if this had been a summary judgment case years before, perhaps we'd be in a different posture today. But there is no doubt.
Well, in the answer, in the initial answer, did he admit signing the note and admit that no payments had been made on it?
There was, yes, Your Honor, there were requests.
That's well before trial.
There were requests for admissions dating back to 2001. However, that did not end the inquiry there.
I know there's other issues, but as far as, right from day one, the defendant admitted, I signed the note, I have made no payments.
Well, respectfully, I would disagree from day one because the answer to the complaint denied the allegations saying that he had breached the note. There were requests for admissions, but if you look at what happened in this case, there was a motion for summary judgment on this issue from Singer that was denied, which would have ended perhaps that inquiry years ago and not required that to be the case. There was a pretrial stipulation saying that the issue of whether or not Green breached on the note was the issue to be tried. There were multiple comments made, including comments during opening statement, questioning that. And so the point being, even if he said, I didn't pay it, they were saying, well, maybe CCC paid it. And again, there was a complication to this thing from the third party who was supposed to make these payments to Green, which then went into account which they were to take. And there were comments made in opening about the alleged breach and about whether or not somehow this was stolen out of there. So just a statement and a request for admission about that did not end the issue.
Well, let me ask you this. Is there anything in the record that would suggest that if the plaintiff would say, look, Judge, if they pay us the $35,000, or they agree to a judgment for $35,000 today, the case would be over? Or was it always the plaintiff's position that the judgment should be more than $35,000?
Well, again, Your Honor, there obviously was a note here that contained an interest provision, and again, that was a contested issue. And so there was, again, the Utah provision that allowed for that amount of interest to be charged. There are Florida Supreme Court precedents that say even if it is usurious, the contractual, deal of the parties often controls over that. And ultimately, the trial court ruled against Singer on that claim.
Was that the issue that was the primary point of the litigation?
Well, Your Honor, if not for the breach by Green of paying this, then none of those issues, which I would consider to be collateral issues, came to be. I think the key issue and the significant issue was trying to prove that Green breached on the note, and that is the trigger that perhaps even gave rise to the issue of interest. It also, without the breaching of the note, was the catalyst for the counterclaim. And so you have, again, a claim on one side for the breach of the note. You have a counterclaim seeking damages. The note is given every penny, with the exception of the interest, and the counterclaim is denied in its entirety.
I go to the language in some of the cases that talks about that the fairest test to determine who the prevailing party is to allow the trial judge to determine from the record which party has in fact prevailed on the significant issues tried before the courts. Not that there are no issues, no other issues, but significant issues. The case law says that the trial court is in the best position to make that determination. And so I'm still struggling with how the trial court abused its discretion in making the determination in this case that the usury issue was really the significant and primary issue before it.
Your Honor, again,
where is that? What do you cite in the record that indicates to us that there wasn't that was an inappropriate finding?
Your Honor, again, I think that there is no doubt that the trial court does have discretion here, but let me cite several cases from this court. Sorrentino, which was a case involving a homeowners association, where this court very succinctly stated the Sorrentinos obtained the result that they sought, preventing removal of certain skylights that they put in there. The association failed to obtain the result it sought, removal of the skylights. Very succinctly, the court said there was a party there that prevailed on what they sought. There's a party that didn't. In this case, you have a party that seeks recovery of money under a note. It prevailed. You have a party that sought damages.
Was your client's goal to recover $35,000 or $100,000?
I'm sorry?
Was your client's goal to recover $35,000 or to recover $100,000?
It was to recover the principal and any interest that it was due. And again, I think that, this court needs to look at, I understand the distinction with the construction lien cases, but there are cases there, for example, Ivy versus Salazar, dating to 2005, where a construction lien was foreclosed for $96,000, but it was offset by more than half, by $50,000, and they still found that they prevailed. Meaning that we don't just weigh, and we don't weigh the number of lines in a judgment.
Construction lien cases are handled altogether differently. There's a history that goes back into construction lien cases that arguably prosperity doesn't apply to. Mm-hmm. And coincidentally, Gale Industries is being argued right now at this very minute before the Supreme Court. So.
And again, and I know that you authored that opinion, Judge Monaco and Judge Evander joined with you on it. And again, there's a distinction in this case, and you made the distinction in that case about construction liens, and that was not a lien case, and therefore the net judgment rule. And I'm well aware of that. But again, just the point being that while construction liens are different, and there is a distinction between them, the cases that rely on, or the cases that approach construction liens still rely on Moritz versus Hoyt, still rely on the prevailing party analysis. What did Moritz say? And again, I think that we can get caught up and get off of...
Moritz predates prosperity, that doesn't it?
It absolutely does.
Yeah. And what effect does prosperity have on your case?
Well, again, I don't know that this is not a construction lien case, and prosperity primarily deals with, again, the net judgment rule in the context of that. And, again, it says that while, and certainly wasn't definitive in saying that a net judgment resolves the issue. But I think, again, we need to look at what the significant issues are. What was the case that Moritz cited? Hensley from the United States Supreme Court, which says the test is whether a party succeeded on any significant issue in litigation which achieves some of the benefit the party sought in bringing the suit. This is not a situation where the court can add up the amount of lines in a judgment or in an order and say this was the primary issue. This is similar to what is the essence of this case. This was a breach of note case.
Let me ask you this. I know there's some factual issues here, but let's assume that on day one it was crystal clear. It's in the record, and the defendant came in and said, "Judge, we owe $35, but we don't owe any interest." And then they proceeded to litigate. Would you be making the same argument that because your client got a judgment for $35, it's still the prevailing party?
I think there would be an argument, Your Honor, based on, again, some of the things that we've seen here in construction lien, in homeowners associations. They recovered what they set out to do. There's a case, again, and we cited numerous cases concerning that. And so I think there is an argument. It would be, I think, probably a more difficult argument. But there certainly is an argument that the essence of the case was to recover on this note. Whether or not the court awarded an additional measure of damages for the interest and in what matter was a collateral issue that was not the significant issue in this case, because if you don't recover on the note, none of these other things matter. In your hypothetical, if it was purely a trial concerning the interest and those things, then we might potentially have a different situation. But again, that's not what we have here. And we have the court changing from the final judgment to this order that was entered months later, that was taken verbatim from the memorandum of law, which the other side filed, which changed the nature of what really went on here. Instead of saying Green prevailed on the first count, is entitled to $35,000, excuse me, I keep confusing the parties, Singer prevailed in the out amount, it says, well, actually Green prevailed on that count. You can't get there from there. Green sued to recover on a note. He won on those things. Singer recovered trying to seek damages. They lost on Green lost on those things. And that is the essence of this case. And while the court, again, has some discretion to look at these issues, this court has not hesitated on numerous occasions to go back and say, you got it wrong. This is the essence of this. The Granoff case also is a very instructive case on this. Judge Sawyer wrote the opinion, but he's saying where you had a homeowner who set out to find that the other side was abusing an easement, the right to an easement. And the trial judge said, well, we gave them some relief and we gave the other side some relief. We're going to give attorney's fees to one homeowner. And Judge Sawyer said, no, you look at the significant issue. Who prevailed here? What was the underlying issue? And the one party won, one party lost. We're not going to add up the amount of improvements that were ordered to be removed or count the number of trees that were taken out. What was the essence of the case? What is the essence of this case? This was a breach of note case. It was stated over and over.
Well, wait, I really thought it was a usury case.
Your Honor, if it's a usury case, then it's affirmative relief being sought by Green on a usury counterclaim to the point where he moved
But it's
for
also
rehearing.
an affirmative defense.
It was an affirmative defense, absolutely, but it was also a claim for affirmative relief to the point where there was a motion for reconsideration after the final judgment entered, arguing again that he was entitled to damages on that. And so again, if you couch this case again in very simple terms, what was sought by Singer, what was sought by Green, Singer got the entire amount of principal, Green recovered zero on what they sought, then I think that is really the essence of the case. I'm going to quickly move to a couple other issues.
You're closing in on 5 minutes, you understand that?
I'm sorry?
You're closing in on 5 minutes.
Yes, is this, oh, I'm sorry, wasn't reset at the beginning, or I have 5 minutes? So I have 5 minutes remaining?
Yeah.
Thank you very much, Your Honors. I'll reserve that. Thank you.
Good morning. My name is Rob Bowling. I'm here on behalf of the appellee, Jack Green. I first want to kind of hone in on a few things that the panel said, because I think it's the most crucial issue for the court to look at in determining the outcome of this appeal. It's been a long case. Hopefully this is the last chapter. To echo what Judge Monaco said, and I think it's Judge Cohen that said, doesn't the trial court have wide latitude and discretion in looking at who the prevailing party is? Moritz gives us the standard for what a prevailing party may be. The fact that there may be no prevailing party is an issue that this court has looked at several times, and those cases, in fact, are cited in the initial brief. But this judge did find a prevailing party, and this judge found that there was a prevailing party by identifying first that the claims that were asserted by Singer were not the significant issues in the case. That's the finding by the judge. But then the court went on beyond that and said, these are the significant issues in the case, these three things. The usury defense, not the counterclaim, which it found to be duplicative of the defense. And of course, the resolution of that defense, if we look at the final judgment, is about half of that final judgment, 15 pages or so, and half of it is dedicated to getting to this usury defense, choice of law, conflicts of laws.
Did you seek a new rehearing or a new trial after the rendition of the verdict in this case, or the judgment in this case?
Yeah, there were issues that, in fact, there was even a
What were the grounds? What did you seek a rehearing on?
On the issues of the usury defenses, Your Honor. There were two issues that were raised.
So they were distinct then from the...
There were. If you look at the pleadings in a pretrial stipulation, the issues were...
Did you lose on the counterclaim?
We did, Your Honor, because the court found it to be duplicative and no damages were awarded, primarily because the court found that Florida law applied and not Texas law. And that was an issue that was, in all candor of the court, argued on a cross appeal in Singer 2, which this court issued a PCA on.
Do y'all ever make an offer of judgment and say, we offer to have a judgment entered against us for $35,000?
I do not believe the record reflects that was done, Your Honor.
Well, would that be a way to alleviate this whole issue in cases where money is the only thing being argued? Not, for instance, a condo association where you're talking about whether improvements should be taken down or not, but when you have strictly a money issue, can't this whole thing be avoided by the use of an offer of judgment?
I think it could be, Your Honor. I certainly didn't. I wasn't the trial attorney on this case, and certainly that's a reasonable thing to do. I don't know that the issue would have been any different had the other side rejected it, rolled the dice, and gone to trial, and we would have still ended up litigating the issue of usury, how we get to usury. I think the findings by the trial court are telling that the loan documents in this case were set up such that Utah law would apply where there is no usury statute that would prohibit the exorbitant interest that was being charged. But to get to that finding, to ultimately prove that Mr. Green wouldn't be responsible for that interest, it took a lot of analysis, and I think that issue still probably would have been tried, assuming that Singer didn't take that deal that may have been offered to them at that time. But we're also forgetting about the history of this case, because it does go back a little bit further. There was an issue very early on that was tried, or wasn't tried, but there were motions for summary judgment granted by the trial court. Those orders were appealed to this court, and the court did issue a written opinion on that. And that was the issue of whether or not this settlement agreement that Mr. Green had with Continental Casualty was security for this loan. Ultimately, that was resolved in favor, we believe, of both Green and Continental Casualty, although Singer may take exception to that characterization. We believe that was a significant issue in the case, and as, in fact, the judge says that was a significant issue in the case. And what I think when we discuss the issue of significant issues, it's not significant claims. I think the more the court was very careful to say significant issues in the case. And while there are all kinds of cases where a party prevailed on a contract claim, for example, and was deemed to be the prevailing party, that's not the dispositive issue in the case. And in fact, the trial court was in the best possible position. The trial judge, although we went from Judge Will to Judge Watson to Judge Graham in this case at various times, I think they're all very capable of looking back at the record and looking at what was done in this case and understanding what went on and making that ultimate decision about what the significant issues were. Whether or not Green prevailed on those issues, I don't think there's any dispute. If you look at the judge's final judgment, the only thing that was awarded to Singer was the principal amount. And also buried in there, I should mention, Your Honors, is not a defense, but a response by Singer that the federal law, the banking laws, would enable them to overcome some of the arguments that were being raised by Mr. Green. That also was decided against Singer by the trial judge. We've talked a little bit about the things that the trial counsel may have said on behalf of...
If the final judgment was so favorable to your client, why did counsel file a motion for rehearing?
The issue, Your Honor, I think it was the issue that the relief that was being sought. Had we been able to prevail on the issue of whether Florida law or Texas law applied to the usury claim, would have given Mr. Green not only wiped out the interest he may have owed, also may have gave him damages as well.
So you lost on that issue?
We did lose on that issue, Your Honor, absolutely. There's a few cases that have been cited in our briefs and actually cited by the judge, and one of those was the Porlitt case where it was a dispute about an expert witness fee, and the expert said it was a fixed amount. The defendant said, no, it's going to be a reasonable amount. The expert ultimately prevailed and got an award of whatever that fee, portion of that fee was. I think it was reduced by like some 25%. And the court said even there, the defendant's the prevailing party because the plaintiff was seeking a fixed amount and it was reduced. The Spring Lake versus Tyrell case, again, a very similar set of circumstances. The plaintiffs obtained a judgment, but it had been substantially reduced due to the defendant's affirmative defenses. And actually there, interestingly enough, the court reversed a finding that the plaintiff was the prevailing party on an abuse of discretion standard. It said, no, it's going to be the defendants here because the significant issues in the case were the amount of reduction in the issues associated with that reduction in the amount.
Let me ask you this. Did the trial judge award the full amount of attorney's fees requested?
The trial court, it's not a precise amount, but it's very close, Your Honor.
All right, so that would include the time spent in a losing effort on the counterclaim and the time spent, although probably small, on the $35,000 note itself.
That's quite possible from the judge's reasoning. What it appears was done.
All right, was there any effort or any argument that should be broken down and that you shouldn't recover for the time spent on the motion for rehearing or the counterclaim? Did that come up at the attorney's fee hearing at all?
I do not believe the issue was raised by us, by Mr. Green, the attorney's counsel for Mr. Green, and I'm not quite sure that it was raised in those terms by opposing counsel. There was some objection to time entries in particular that were raised, but we really don't know, given what the judge did here, exactly how he came up with his precise end number. I can speculate and say that what he did was he took the 319 hours that were submitted on the actual bills. He multiplied those by the hourly rate that he found. And that comes very close to the number that was being sought, which was actual time spent at reduced rate of 125 hours, plus pursuant to the agreement between the attorneys and Mr. Green, that there would be an additional 50% of the savings that was associated with a successful defense that would be tacked on. And those numbers are very close, but they're not exact. But no, Your Honor, I don't think that there was any effort by the judge in this case to do that, although he certainly did have the evidence in front of him to do that. The issue of what was submitted to the court, I think, is important here. The bills were submitted to the trial court. The testimony of Mr. Green, Mr. Shoshone, the attorney who handled it, and Greg Snell, a local attorney who was also testifying as an expert. In addition to that, the bills associated with Singer's efforts in this case, because they had filed a motion for fees, were also part of the record. And although Mr. Carlisle didn't touch on it in his argument, it's certainly in the briefs, and we think it's important enough to address it. We don't need to have evidence in the record by an expert witness to satisfy the standards set forth in Roe. There needs to be enough evidence in the record for the judge to make those findings. We certainly believe that Judge Graham was in a position to review all that evidence and did make specific findings with regard to the Roe factors, and we believe that's just not really an issue. There's also some discussion in the initial brief, Your Honors, about the conclusion by the trial court that in addition to deciding that Green was the prevailing party, that Singer shouldn't be able to collect any attorney's fees because of the finding of usury. We submit to the court that, for one, that would be harmless error if you otherwise conclude that the trial court didn't abuse its discretion, that irrespective of that finding, the result should stand. Even so, Singer tries to argue to this court that there's a way that the trial court could have separated out its prosecution of its case of the principal only versus the principal and the interest, and come up with a non-usurious and usurious side of it and pull that back, and they could be awarded those fees. We just don't think that's possible. And the cases they cite for that proposition are cases where you have a foreclosure action coupled with a breach of note. They're distinguishable. I think the Wilson, the Maxwell, the Hagan, the Purvis case, all are distinguishable. They simply cannot support the proposition in that regard. Finally, I think as to the issue of who the prevailing party was, Singer asked this court that if it doesn't agree that it was the prevailing party, this court should nonetheless determine that neither side prevailed. And certainly this court has determined that, I think following, it was a Lasco case, I think, but kind of receding from the more strict application that there must be a prevailing party, has said that in compelling circumstances, as referenced in many other cases before it, there can be where no party prevails. I think that's within the trial court's discretion to do that. In this case, he didn't make that finding. He found that Jack Green was the prevailing party on the significant issues in the case. He listed the issues that were significant. He was in the best possible position to do that. And I think the standard for abuse of discretion is finding that no reasonable person would reach that decision. If reasonable minds can disagree, I think it's well within the judge's discretion to reach the conclusion. We believe that the trial judge in this case did do that. With regard to procedural irregularities argued in the initial brief by Singer regarding the reopening of evidence, we believe those speak for themselves. We'll rest on our brief on those issues. And as a final point on the issue of the entitlement to attorney's fees from Singer 2, which Singer now asks this court to revisit in the vein a la, I guess, VLX, this is simply not a case where manifest injustice has resulted, and there's no basis for this court to be reviewing again the decision to award appellate attorney's fees. And for these reasons, we ask that this court affirm the lower court's decision. Thank you.
Thank you, counsel. Mr. Carlisle, you have 4 minutes and 57 seconds.
Thank you very much, Your Honor. The key here, again, is the significant issues in the case, not the collateral issues. We have a situation where a party was forced to sue on a note, and again, this went to trial, and we cited numerous things in our brief, opening statements by the opposing counsel. At no point was ever Green supposed to write a check. Somewhere along the line it failed, and it was not the fault of Mr. Green. This is the argument that's being made at trial, that he did not have any fault in the fact that this note was not paid. This issue went through trial. You have a party that was forced to sue on it that has to litigate all the way through trial whether or not the other side is liable for this note. You have a legitimate note that has a choice of law provision that ultimately you lose on that issue, and then you're penalized for that. For this court to rule in favor in saying that was the significant issue is to take creditors and say, you know what, any possible argument about an interest provision, you better not even try to get those things because you might have it turn around and bite you on the attorney fee issue at the end of the day. And oh, by the way, even though they sought affirmative relief on the other side and lost, you still might get bitten and come out on the wrong side of this thing. Frankly, that's not right. It's not the significant issue. The issue in this case was a breach of note case. Singer prevailed with every penny of principle that it sought. Nothing changes that fact. While the usury issue was complicated and was a source of considerable consideration by the court and took up a lot of the final judgment, again, part of that was the issue that was raised on motion for rehearing, which is Texas law versus Florida law, the affirmative claims that were sought for damages by the other side, which were rejected by this court. But even that being the case, the significant issue was this was a note case. This is, again, I know the court has expressed reservations and distinctions, but it's, again, a construction lien case. It's a homeowners association case. Who prevailed? In this case, to look at this record and suggest that Singer, who recovered every dime that it sought, a principal, did not prevail in this case because it tried to enforce a legitimate interest provision in a note and ultimately lost on the legal issue is frankly not the significant issue, or to say that other issues are far more significant isn't the law. It isn't what Moritz holds. It isn't what this court has held on numerous occasions in reversing trial courts where they abuse their discretion. Thank you very much.
Thank you, counsel.